Welcome back. Uh, in this lecture, we are going to understand theory of rights and what it means to have rights and what it means by this word rights. Right. So, what is rights? What is rights? You must have must have studied about fundamental rights. What are fundamental rights? What are fundamental rights? Fundamental rights are essentially civil political rights. Civil political rights and fundamental rights are such civil political rights which which uh, which limit powers of state. Example: Article 14, equality before law. So state have to keep everyone equal before law, and application of law will be equal across time and space, and it will be irrespective of individual. Then you see Article 21. Article 21 is right to life and liberty. Right to life and liberty. This right basically limits the state and says that there are some non-negotiable rights which a individual should have. Then you see article 20, article 20, writs, right? Article 20, writs, habeas corpus, writ of habeas corpus. All these writs can be issued against state, can be issued against public authority to show why a particular thing has happened, or court can coerce a particular public entity to do something. So are rights are powers or entitlements of individuals over state. Rights are powers or entitlements of individuals over state. Rights limit state, right? Rights limit state. It is against state. It is an anti-statist concept. It is against state, right? So rights are entitlements, rights are powers, right? Rights are rights have emerged in modern times. Rights have emerged in modern times, and rights talk about human rights of a person, natural rights of a person, and it rejected that divine right theory. If you have read Robert Filmer, his Patriarcha, and there is this divine theory of rights theory as well we have studied in ideologies. So so it is against that. Rights as a modern concept is for subjects, not the rulers. And in modern way of life, natural rights asserted themselves, rights of individuals, powers of individuals asserted themselves. So what are rights? Rights are powers or entitlements of individuals over state, right? Some scholar interpreted it in different ways. Dworkin interpreted it. Dworkin interpreted it. Right to be trumps. What does this mean? Rights are trumps. They are like trump card. Trump card. If you are not, if you are not okay with something, if you are thinking it is like a last resort, it is like a last resort. When everything else has been used and not worked, you are going to use rights. My right to property is not being taken care of. I'll go to court, and that is my trump, right? Then Lasky says, rights are the conditions of human life without which no man can seek in general to be at his best. Lasky. Then Lasky says that rights are essential conditions which are essential for human development. You need right for development or development of virtues. Right? Rights are needed for development of virtues. On the other hand, Marx in his book Jewish Questions called right a bourgeoisie concept. Marx called right bourgeoisie concept. So you can see there is not one conception of right. There is not one understanding of rights. Some people say rights are good, some people say rights are bad, some people say they are bourgeoisie, some people say they are natural. Dworkin say they are trumps, and Marx say they are bourgeoisie, right? So there are multiple interpretation of rights. There is this one scholar, Hohfeld, Hohfeld, who who categorized interpretation of rights and who understood and codified types of rights. So interpretation of rights. By Hohfeld. Hohfeld. Hohfeld gives gave gives four interpretation of rights. Hohfeld gives four interpretation of rights, of which first is rights as claims. Rights as claims. What is rights as claims? When when one has one has claims on other to do a certain thing. When one has claims on other to do a certain thing, I will say Article 32. Article 32 is basically protector of your rights, right? It is protector of your rights. Article 32, it is protector of your rights. Article 32 is rights for to have rights. So we can claim on state by invoking Article 32 that we need rights. That is claim. I will ask I will ask other to do a certain thing and they have to do that. So that is claim interpretation of rights. Article 32. I have claim on state that it will protect my right to have rights. It will protect my right to have rights. Then rights as privilege. Rights as privilege. Such rights privileges are rights limited to few. Example will be parliamentary privileges. Article 105. Or presidential privileges. Article 361. Whereby parliamentarians have immunity in whatever they say in parliament. They can say anything in parliament and get away with it. Then presidential privileges. Article 361. Whereby president has legal immunity in criminal cases and in civil cases. President has absolute immunity with with respect to criminal cases, not civil cases. My bad, but criminal cases, right? Then this example also fits in another interpretation of rights, but parliamentary privileges, Article 105, is an example of privilege. I will give you another example of privilege. King of England is the only person in the world who does not have a passport, right? And he has that privilege that he does not need passport to move across nations. Why? Because passports are made in his name. Passport are made in his name. That is why he does not need passport. That is a privilege that King of England has, right? So rights as privilege. Then rights as power. Rights as power. What is power? Power is capacity of a to make someone else do something which she or he does not want to do. That is power. Rights can be powers as well. And the fourth interpretation of right or four types of rights is power rights as immunity. What is immunity? That you are not answerable. You are not answerable for anything that you have done. Then Article 361 presidential powers, presidential immunity against criminal cases. So rights have four interpretations. First, it is of claim. Second, it is of privilege. Third, it is of power. And fourth, it is of immunity. Rights are claim of one on another. Rights can be privilege, rights can be powers, and rights can be immunity. Right? So this interpretation of rights say that immunity, power, claim, and privilege are mutually exclusive. Sorry, not like this. They are mutually exclusive. Claim, privilege, power, immunity are mutually exclusive because according to Hohfeld, according to Hohfeld, they are different. But in real life, it is not true. That is not true. Article 32 can be interpreted as both power and claim. I have claim on state so that it does something for me, but I have power on state as well, right? Then there is Article 361. Article 361 is immunity and its presidential privilege as well. It is a right which is limited to president, and it is immunity of president as well. Parliamentary privileges are privilege of parliamentarians, and their immunity of them there as well, right? They have this immunity as well. So rights are not mutually exclusive in these four types. They can be they can be present in compound. That rights a right can be both claim and both privilege. A right can be a power and immunity as well. So rights are not granular or nuclear. Rights are present in compound. Rights are not granular or nuclear. Rights are present in compound. Hoffeld thought that Hoffeld thought that rights are mutually exclusive in these four types, but it is not true. They are present in compound. A claim can be immunity as well. Claim can be power as well. That is the idea of it. They are not granular. They are not granular or nuclear. What is granular? Which means that grains of grains of these rights are can be separated. Nuclear is nuclear. They are not in silos, but they are present in they are present in they are present in compound with each other, right? So that is Hohfeld's view on interpretation of rights. He said rights are claim, privileges, powers, and immunity. Then we see then we see another categorization of rights as well, which is types of rights by Karl Wasak. Karl Wasak's Karl Wasak's theory, it is based on Marshall's theory of citizenship. What is Marshall's theory of citizenship? Marshall says that Marshall says that in evolution of definition of citizenship, in evolution of definition of citizenship, it was it was evolved in rights. Citizenship was evolved in accordance to definition of in accordance to rights you have. So Marshall say that Marshall say that civil rights were the first rights that were given. Then he says political rights were the next rights, and social rights were the rights given after that. So he says that citizenship is closely related to rights which are given to its citizens. Citizenship was defined earlier in terms of civil rights in 18th century. Then citizenship started on basis of political rights in 19th century, and in 20th century Citizenship is being defined on basis of social rights. Right? This idea that this idea that citizenship is dependent on rights was used by Karl Vasak to give his theory of rights, to give his theory of generation of rights, theory of generation of rights by Karl Vasak. Vasak gives three generation of rights, right? First generation of rights, first gen. First generation of rights is civil political rights. Civil political. What is the origin of civil political rights? Liberalism, right? What are civil political rights? What are civil political rights? Civil political rights are right to participation in affairs of state. Civil political rights is against arbitrary arbitrary powers of state. Civil political rights establish democracy, right? Civil political rights are on individual basis. These rights are of individual. Civil political rights are of individual, and they are of negative liberty, right? Civil political rights will define the walls within which you have to move, right? These are civil political rights. Then he gives second generation of rights, civil political rights based on liberal ideas, based on idea of negative liberty. Then he gives second generation of rights, second generation of rights based on socialism, based on socialism. Second generation rights are socio-economic rights. So basically, rights of roti kapda makan, roti kapda makan, not really political rights. First generation rights can be thought of as fundamental rights. Fundamental rights are nearly all of them are civil political rights. Socio-economic rights are roti kapda makan. They are class driven. They are class driven. And the second generation of rights of socio-economic rights is based on positive liberty. First generation of rights were based on negative liberty. Second generation is based on positive liberty. Right? First generation rights are negative liberty and procedural equality or equality of opportunity. Second generation is positive liberty, substantive equality, or equality of outcome. Then he gives the next generation of right, third generation of rights. Third generation of rights. Third generation of rights are cultural and developmental rights. Cultural and developmental rights. These are community based. What does this mean? This means that Muslims in India have rights of having separate personal laws, right? These third generation of rights say that you can have specific set of rights within your community. What is communitarian theory of justice? What is communitarian theory of justice? What is it? Communitarian theory of justice basically is an idea which says that within a particular community you can have particular principle of justice. Similarly, cultural and developmental rights say the same thing, and it says for a particular community you can have particular set of rights. You can give community based rights. That is the idea behind types of rights. So we have seen interpretation of rights as claim, privileges, power, and immunity. We have seen types of rights uh, by Karl Vasak, and and we'll start with rights in liberal discourse and how rights are seen by liberals. Then we'll see theory of natural rights in the next lecture. Thank you so much. Bye bye.